they've boxed themselves in, and that would touch virtually every single firearm.
Oh, yeah.
We are the Armed Attorney. Today, we're giving an important update on an assault weapons ban. Now, this could have nationwide implications, and we see a bunch of states' attorney generals, even those in what I would consider pro 2A states, jumping on the bandwagon, and that's kind of cause for concern. You're going to want to know who these bad actors are, but before we begin, show your support for the Second Amendment by hitting that like button. And today's video, no sponsor, but we got a special ask for you. Make sure that you are subscribed. If you're already subscribed, hit subscribe again. Well, hit it twice because then you'd unsubscribe. And then okay, just make sure you're subscribed. Now, YouTube has been monkeying around with subscriptions and stuff. We call it the anti-2A algorithm, and we'd really appreciate your support. Now, we're talking about the Miller v. Bonta case, and if you're following along or if you want to look this case up, it's 19 CV 1537. This is the California assault weapons ban. They call it the Assault Weapons Control Act. And going back to October, the district court there invalidated this law, saying, hey, guess what? This was an unconstitutional infringement on the Second Amendment. We now have an appeal to the Ninth Circuit Court of Appeals that have stayed that decision. And now we have a ton of states' attorney generals jumping on a bandwagon, even some states that really surprised me, saying, hey, guess what? This is a proper law that cohabitates and is perfect with the Second Amendment, doesn't infringe the Second Amendment. And it's kind of disturbing.
Yeah, well, what they say is that they say that assault weapons, as defined by California, and I'm sure that they think as defined by any law which bans assault weapons, that those weapons are not designed to be protected by the Second Amendment because they are not in common use for self-defense, which is an absolutely ridiculous argument. But yeah, you're right. With regard to the state's attorney generals, we see states for the state attorney generals from Arizona, Colorado, Nevada.
Vermont was another one that surprised me.
Vermont, Maine, which has always been very pro Second Amendment. Basically, overall, it shows you that there really is no such thing as a pro Second Amendment Democrat anymore. I know that back years ago, there used to be, Democrats from conservative states, Democrats that held some conservative views. Those people are gone. They are gone. And the entire Democratic Party is controlled by the anti-gun folks. And I think this proves it. I mean, my God, if the Attorney General of Arizona and Nevada come out and they sign a piece of paper that say that assault weapons bans they're all perfectly good and these are not protected weapons. I mean, you pro Second Amendment people in those states, you really need to examine and come out and try to get rid of those office holders.
Yeah, so let's go through this list and talk about kind of the arguments that are being made in this. Our list is New Jersey, Massachusetts, Arizona, Colorado, Connecticut, Delaware, the District of Columbia, Hawaii, Illinois, Maine, Maryland, Michigan, Minnesota, Nevada, New York, Oregon, Pennsylvania, Rhode Island, Vermont, and Washington. No surprises there with a couple of these folks, but as we said earlier, like Nevada, Arizona, Vermont, Maine,
Michigan.
Yeah, Michigan.
Michigan's been the home and Pennsylvania. They've been the home of sportsmen and Second Amendment protectors. It just it boggles my mind that the Democratic attorney generals would sign their names to a piece of paper and obviously do it without fearing any political recourse.
Yeah.
So that's what's very disturbing. And of course, their argument is totally ridiculous. They've really bought into the whole Biden argument, the Biden lie that we've heard him say many times about, well, when the Second Amendment was written, you couldn't own a cannon.
False.
That is totally false. But no, of course, the media is not going to call him on it. And so they've kind of fell into this. Well, geez, the Second Amendment couldn't have contemplated protecting all these horrible, horrible, destructive weapons of war. But in fact, it did.
Yeah. So let's go through kind of the arguments that they make, because some of these are refreshed, but some of these are I'd say a little bit of a twist of things that we've seen in the past. The first big argument that they make that kind of stood out to me was saying that assault weapons, again, not defined in the brief that they provide us. They're basing it just off of California's law. That's perfect. That's what we're going to call assault weapons. They're saying that those are not suitable for self-defense.
Well, of course, which is absurd. Any weapon, and keep in mind, an assault weapon is still a weapon, a firearm that only shoots one bullet with one pull of the trigger. And so I would say that there are many weapons that can be used for self-defense that fall under this category. In fact, one of the ones that and this is in the federal assault weapons ban, the original one
And
that
94.
continually, the original 94 and the one that continues to be applied now, is they say they want to outlaw, they want to consider handguns, which have a fully automatic version. A semi automatic version of a fully automatic handgun is considered an assault weapon. Now, in 94, that wasn't that bad because in 94, you had to have two characteristics
Right.
in order to be considered an assault weapon. However, with every proposed federal assault weapons ban and most state assault weapons bans afterward, say that you only need one characteristic, which includes being a semi automatic version of a fully automatic weapon, which of course would include, in my opinion, it could be legitimately read to include every single Glock handgun.
Yeah, I think that's oftentimes overlooked. I mean, think about 1911s. All right, they got an automatic counterpart, or you look at Glocks, or virtually all these weapons are made for typically military, and then they remove the automatic component for the civilian market. So, I mean, really, they've boxed themselves in, and that would touch virtually every single firearm.
Oh, yeah. And so to say that the semi automatic version of an automatic weapon is considered an assault weapon, therefore not being capable of being used or not commonly used for self defense, is an absurd argument.
Yeah, and I'd say the other one that always gets in my craw with this is the police carry, and again, this is not our term. We're saying what California is calling these things, what California would call an assault weapon. I mean, virtually every cop has one of these things sitting in the trunk of their car. And you have to ask, if it's not for self-defense, then why are the cops running around with these things? Well, you see that argument falls apart very quickly. I mean, there's a legitimate, oh, dang, they're more accurate. Oh, dang, they can get on target. Oh, man, they can shoot over longer distances. All those kind of arguments go out the window.
And of course, remember also, California believes that any firearm which holds more than 10 rounds of ammunition is an assault weapon.
Yeah.
So
Wild.
how on earth could that logically be held to not be in common use for self-defense?
All right. The second argument, and this is a common one. However, this is probably the first time I've seen them try to twist Heller and Bruen logic in a direction that it has never gone before. They talk about the historical tradition of regulating assault weapons. If you're listening, I'm making air quotes with my hands. They cite Heller and Bruen and say, hey, guess what? Heller and Bruen brought up felon in possession laws and mentally ill laws. So those are new laws. So if they brought up modern laws, we can bring up modern laws.
Yeah, no, it's completely a false analogy here to say that those are equivalents.
Right.
Because of course, felons and mentally ill, those go to individuals. We're talking about here regulating inanimate objects. And so they're definitely not the same.
No, and they cite to, they are really dead set on citing Reconstruction era laws. So we're talking 1860s, 1870s law in order to justify infringements on the Second Amendment. And that is just not the time period we should be looking at.
No, it certainly is. And it's amazing to me how these anti-gun folks continue to try to put lipstick on this pig whenever they know, or at least they should know, that the Reconstruction era is not the relevant time period in looking at Second Amendment interpretations.
In bringing up those laws, I'd say one of the oldest laws that they cite is a 1930s machine gun law saying, hey, look, we have the National Firearms Act. We have these restrictions on, automatic weapons. 1930s. Again, that's not the time period we should be looking at. We should be looking at the time that the Second Amendment was adopted in 1791. And when we look at what restrictions on arms were at that time, that list is virtually non-existent.
No, not at all. I mean, they didn't, the fact that they are trying to use the NFA restriction on fully automatic weapons is again completely inapplicable to this particular situation.
When we look at the restrictions there, I mean, they're are a handful of restrictions and they fall under different categories. I mean, there are some people who might be prohibited. There are some places that might be considered sensitive places for purposes of 1791. And we have to acknowledge the historical record. But there just isn't anything here as it relates to assault weapons.
Yeah, because the thing is that all these restrictions, it dealt with either people or places or conduct.
Yeah, conduct.
It didn't deal with the weapon itself. So saying that these are analogous and we can regulate the weapon, the inanimate object, because we had these other restrictions, like I said, it just doesn't make logical sense. But we're not really we don't really come to expect logic from the anti-gun folks.
I will just say, first and foremost, that list of states, that is I would say, the part that surprised me the most. If you find yourself in one of these, what I would think of as a pro 2A state, and your attorney general is jumping on this bandwagon, it might be time to be writing a letter, picking up the phone, and airing your grievances about these policy decisions.
I know, Arizona. I mean, hey, Arizona, have y'all had that many Californians migrate to Arizona? And Nevada the same way.
Yeah.
And that's what I am deathly afraid about Texas.
Yeah, but we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video. And we always appreciate your questions in the comment section down below. And until next time, we're the Armed Attorneys. So much glitter. Don't California my Texas.
Mm-hmm.